The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Once again, please be seated. Okay, this afternoon we have just two cases. The first case is Bradley A. Chicoine and others versus Wellmark, and the second case is Iowa Supreme Court Attorney Disciplinary Board versus Paul Kevin Waterman. That last case is just now submitted to the court without an oral argument, and we'll proceed to the final arguments in our trilogy of cases here. So, Mr. Wandro, nice to see you, and you may proceed.
Thank you. Round three. May it please the court, counsel, Steve Wandro for the plaintiffs in this action. Well, I'll cut to the chase as well, and we are taking issue with the district court in enjoining the Chicoine action indefinitely until the MDL in the Northern District of Alabama runs its course. And like the defendant in this case, we're searching for precedent that might give this court some guidance as to how we handle this situation.
Counsel, sorry to interrupt you right out of the box, but when you say runs its course, it's unclear to me whether that would mean until the pretrial proceedings are done, or whether it refers to the post-trial state of the two bellwether cases. What's your understanding?
Good question. What the MDLs do is to tee up the pretrial matters, and generally it's procedural. What the federal MDL statutory scheme envisions is that all of these cases that have been filed around the United States are venued in one jurisdiction, and it's the Northern District of Alabama. So they will deal with preliminary motions like motions to dismiss, getting the cases ready, with the notion that at some point those cases will be remanded back to their original jurisdictions. Of course, the problem here is we're not part of that federal scheme. We're a state court. But so when I say run its course, I'm talking about if it gets that far, is to get it to the point where the district court says, federal district court in Alabama says it's time to remand and give these cases, they're all ready to go. We've got all the pretrial issues taken care of. Now go try your case. So that's what I'm talking about, running its course.
But let's assume that happens. The case survives all the pretrial proceedings. Case says now it's time to go home. Mm-hmm. Does the Pharisee case get tried and you're still stayed until that's completed? I mean, how's that? How do the relative positions of the parties?
That's the problem, I think, with the district court decision, is the fact that they didn't give a whole lot of guidance. But what usually happens is in an MDL bellwether case tried somewhere. And in fact, if you look, Judge Proctor, who was the federal district court judge in Alabama handling this case, just got done. In fact, it's not a part of the record, but I looked at, before this hearing to see what was going on down there, and he just ruled on a motion to dismiss. But certainly the court is contemplating that for the two cases that originated in Alabama, that they might be tried and they might serve as a bellwether to lead to settlement of all the other cases. And quite frankly, that's kind of what happens in MDLs. If there's a trial, there's a bellwether, and then after that, people come to their senses and get the cases settled.
Has there been a subclass designation for Iowa? I know that's kind of mentioned in the briefs. Has there been any type of designation of a subclass for Iowa?
I believe that there is, but there's been they're not even to the certification stage of that litigation yet. Again, they're at the very incipient stages of the litigation in Alabama after, being in existence for a year and a half or 2 years.
I mean, is there kind of I'm just kind of thinking, out loud, which I guess is dangerous, but isn't there kind of a conceptual difference between the MDL and Alabama in your case? I mean, your case has always been about Wellmark allegedly sticking it to chiropractors. And as I understand the MDL, the theory is that, you know, Wellmark conspires with Anthem, conspires with all the other Blue Cross entities to not compete with each other and stick it to everybody who's a provider. Am I missing something there?
Spot on. Look who are the plaintiffs or the putative plaintiffs in the Alabama case. I mean, it goes from MDs, DOs, physical therapists, dentists, radiological equipment providers. And yes, there's a territorial allocation problem, and yeah, they're saying stick it to everybody. And we know what the secret of our case is: discrimination. We've been arguing that for 10 years. And that is not any part of that Alabama proceeding. There is absolutely nothing in that Alabama proceeding in the MDL that has to do with 514F, which we're all considering here, especially yesterday. So when you look to some kind of guidance, even if we assume that the MDL runs its course, it will not be a complete, full adjudication of the issues. There will still be issues here. And remember, MDLs are creatures of a federal statute. And if you look at the Bear case, which we cite, a Supreme Court case, you know, there's not going to be any preclusive effect of any adjudication in federal court. You know, the state courts, as a sop to federalism, the Bear case said, you guys, state folks, go do your thing. The federal courts will do their thing. That's the problem I see with the MDL here.
Mr. Wandro, help me out. I frankly have some difficulty separating the notion of a claim based upon fee or price fixing and the theory of discrimination against chiropractors. It strikes me that those two ideas are really so intermeshed that it's hard for me to separate them. Maybe you can help me understand how they're different.
Well, to an extent, they are very much together. But remember, the discrimination that we are alleging in this case also has an Iowa statute component that has to be taken into account. So, yes, are there overlapping issues between the Iowa litigation and the federal litigation? Of course there are. There are. That's no secret. The problem is the fact that we still aren't going to get a full adjudication of all of the issues from the federal courts, nor are they binding on us. And guess what? We can opt out, which, if I'm going to be running this litigation after if Mr. Norris doesn't heal up, I'm going to suggest to our clients that we opt out, and we're going to be back in this court anyhow. And we're going to probably be running on, instead of 10 years of litigation, 15 or 16, if we have to wait all of this out. And remember, too, we have guidelines on how these cases, complicated cases in Iowa, should be adjudicated. In the business courts, it's 24 months, unless there's extenuating circumstances. In a regular case, it's 1.5 years. We've already got 10 years under our belt.
Plan to, or have you been relying on discovery depositions that are taken in the MDL?
I don't know if any depositions have been taken. No, we haven't relied on any of that.
In light of the overlap, would it make sense to have a partial stay but allow unique aspects of your case to go forward in Iowa? And maybe I should first ask, in your view, do we have a binary choice? We either reverse or affirm, or can we modify and narrow the scope of this stay?
I think the court can do the latter if it chooses to do that. There's nothing that prevents it from doing it. I mean, you know, as much as we look, both of us, to First Midwest, this isn't a case of abject foreign shopping where you've got the exact issues and the exact parties being litigated in Nebraska that are being litigated in Iowa. This is a hybrid, and Judge Huppert alluded to that fact, that this isn't a complete identity. But I tell you what, we don't have to go south of the Mason-Dixon line to get guidance from the federal courts on how to handle cases that aren't heavily adjudicated in Iowa, like class action lawsuits and like restraint of trade cases. We don't have the volume of cases that the federal courts do. And what do? We don't have to go to Alabama to have this court or the district court look at what's happening around the country. We don't have to be stuck in that purgatory for another 6 years or so in order for this court to find out what other courts are thinking and maybe come to a sensible solution.
The 6 years or so that you just adverted to, I guess I'd like to know your best judgment on how long the pretrial phase of that MDL 2406 is going to last.
In the record, we allude to, I think one of the administrative services say the average MDL lasts 6 years. Justice Hecht, I've been involved in the Fen litigation that started in 1998, and I recently settled a case, and that's, nearly 19 years in the making. I mean, I don't know in a case like this is how it's going to metastasize, but I would say, I would use as a yardstick, I would probably say 3 years, given the nature of this litigation and the fact that I've been involved in other restraint of trade cases that go through class certification.
McCarran-Ferguson Act, if the have the blues and the MDL raise that as a defense, that there's that the state, the immunity based on the McCarran-Ferguson Act that protects the business of insurance from the federal antitrust laws, but maybe not from the state antitrust laws. Has that been raised?
If it has been, I don't think it's been adjudicated, and I just don't know, but it is very typical in these kinds of cases, insurance versus, as we've argued in, I believe in this court, the business of insurance. There's a distinction. I would imagine that I'd be surprised if that was not raised, but I don't know that for a fact.
I guess I'll just ask a question as well. We're here on an abuse of discretion standard, and that's always a very difficult and high bar, I think, sometimes for somebody in your position to meet. And so when you look through, I know you had a full hearing in front of Judge Huppert in this case, and then he renders his decision, looking at all the factors that are here, and then he comes to a conclusion that you just happen to disagree with. But how do you get to that point of saying that his ultimate decision in this case then was an abuse of discretion, that it's somehow, I'm not sure this is the correct standard, that it was arbitrary or capricious or somehow, certainly there's not a claim that this is legal error, I don't think, that you're saying, or maybe you are, but how do you get over that for me?
Well, I can tell you, on being on the receiving end of that, nobody likes getting in the position that I'm in today to argue that a court abused its discretion. So my response to you, Justice Hager, is twofold. The first is, when we get into cases of class actions, and that of certifying a class action, and I do a fair amount of that work, it's discretionary. But when I read this court's decisions or the Court of Appeals decisions on abuse of discretion, I get the sense in my gut that it is more than just untenable or clearly erroneous. And that's the standard that's articulated as to what we have to show. I think it's a more searching inquiry. So what I would say to you is there's probably a little higher standard that you folks are utilizing in these kinds of cases when you look for an abuse of discretion, which makes it easier for me. But given the fact that we're talking about an indefinite stay, and totally beholden to something that's happening far away and that could last for a long, long time, I do think it reaches that level. But you're absolutely right. Is my burden hard today? It is. It's a hard burden to shoulder. But I think we met that burden.
One of the arguments made in the Wellmark brief is the claim that you didn't make this argument about the differences between the Iowa action and the federal MDL action in the district court. Do you want to respond to that?
Well, I think we did. It wasn't the focus of the hearing, but I was being facetious when I read that. I was thinking, boy, did I miss that flyer that this case was about something other than discrimination against chiropractors that we've been arguing for the last 10 years. What was in front of the court, and there's no doubt about that, and it's in the record, is our petition in Chicoine, where if you go through our allegations of specifications of a restraint of trade, discrimination is all over those pages. And Mr. Norris did talk, albeit briefly, about it. There's no surprise there, Judge, and we just don't give a lot of merit to that argument. I see my time has run up. Thank you.
You may sum up, Mr. Wandro. I know we've tossed a lot of questions at you, but you may sum up if you wish.
Judge, we feel that, in responding to Justice Hager's question, we feel that the district court did err in imposing an indefinite stay. We believe that the reasons are very, very compelling, that stay needs to be lifted, and that this court, or the Iowa courts, go ahead and adjudicate this case in Iowa. Thank you very much.
Thank you as well. Mr. Koopmans.
Thank you, Chief Justice. May it please the court. I'd like to pick up where you left off, Justice Hecht, and then follow up with a description of really what are the claims in this case, which I think goes to your earlier questions and to Justice Mansfield's questions. So, and also, Justice Sager, the standard is an abuse of discretion, and it is a high bar, especially in this case where he's not dismissing the case. He's not changing the case. He's just putting it on hold, and Judge Huppert is managing his docket. And so when we filed the motion for stay, we had a complaint in front of us that is many, many paragraphs long, most of which have been pre-copied from previous petitions, including ones that argue about the insurance law that we talked about yesterday. So this discrimination issue keeps coming up again and again and again, and that was in the petition. But we described in our motion to stay what these claims really were at the heart of them, what this new theory was. We laid that out just like we laid it out in the brief to this court, and there was no disagreement with that characterization of the claims, only about whether they should be stayed. Only now is there a disagreement saying, well, really, this case is about something completely different than what the MDL is about. So now I want to turn to that issue, though, about really what this case is about, and maybe, to your point, Justice Waterman, about whether some claims go on, some claims don't, because what Mr. Wandro said is this is about discrimination, and that is what they have been worried about all the time. And I don't doubt that. Really, they're just finding any kind of cause of action to get to that discrimination. But if you look at what their claims are, geographic market division and restraint of trade and combination and conspiracy, the elements of those claims, that is not a discrimination claim. And how I know that, and why I guess we can go talk to the district court about discrimination, is there is no such thing as a discrimination claim under Section 1 of the Sherman Act. It does not exist, and we cited that in a footnote in our brief. So I have never heard what these elements of discrimination are, and I'm still very confused about what that means. What they have alleged...
About this theory, again, I'm thinking out loud, but that's dangerous, and I acknowledge it. But, I mean, could the argument be, because I sort of teased this a little bit out of their briefing, and I haven't looked at this in much detail as I should, that allegedly the Blues are in this horizontal conspiracy that drives down provider reimbursement. The problem is in Iowa that you have Unity Point and you have these big hospital networks, and they have enough countervailing bargaining power. They can countervail that monopsony, any monopsony power of Wellmark, but the chiropractors can't. I mean, I get sort of a suggestion like that of a theory, and that would be both a sort of a price-fixing theory and a discrimination theory.
Well, it's not a discrimination theory. It's just, I think, more properly labeled a theory that is only applicable to chiropractors, not a discrimination theory.
That would be fair.
As such, right. Okay, so let's take that claim and extend it out. So what they are saying is that the market here, we have a monopsony issue here. So the market is a purchase for health care services, right? And that's what Wellmark is monopsonizing, right? And so first we have to define the market. Well, what is the market? Is it really just chiropractic healthcare services? Because yesterday we heard does the exact same thing, that chiropractors and physicians do the exact same thing. So why is the product market here only chiropractic services? That is actually an issue that is going to be and is being litigated in the MDL because they have to define what the market is. More complex yet, though, is that really the scenario that we're working under? So in 2000, a theory came out, which now has got a professor a Nobel Prize in 2014, about two-sided markets, two-sided platforms. And that is one of the major and like the antitrust cutting-edge issue that is being litigated in the MDL. So it's not is the product, the healthcare services that Wellmark is buying, and they're the purchaser. Really, the product is the provider network, and that has two sides. It has customers who are the insureds. They like the provider network, and they like the provider network more if there are more providers in it. Then you have the customers on the other end, which are the providers. And really what they're doing by the discount is they're paying a fee to be a part of the provider network. And the bigger discount they're willing to pay depends upon how many insureds are in there. And so the increase of price of one affects the other. And so what will be litigated in the MDL is if you destroy this kind of ability to share provider networks and to do what the Blues do, then you are necessarily going to be affecting the insureds, and you have to look at it, the whole picture. And actually, there was just a case in September out of the Second Circuit dealing with credit cards. So there you have the cardholders and you have the merchants. And they went through 5 years of litigation, had a bench trial, and the court ruled that American Express had monopolized in some way, had done something to one side of that market, the merchant market. The Second Circuit reversed and said, no, you started off on this thing all wrong. You have to look at it from a two-sided market.
You sound very, very capable of defending Wellmark in the trial court here, here right now. Why do we need to defer and wait years for this MDL to be resolved?
Judge Huppert asked the same thing, and I think he thought, well, I think he and the court was able to do it, and I said, I agree. The problem isn't that that this court, the Iowa State Court, is unable to do it. It's that ultimate decision, Iowa law requires us to look to federal law and to harmonize it because this is an interstate commerce issue and also a health insurance issue. So in no other matter is it more important to harmonize the law and not affect what's happening outside. So the issue isn't whether I can litigate it or Mr. Norris or Mr. Wandro can litigate it. The issue is let's wait and see what the court decides, what law applies.
That doesn't mean harmonizing to interpretations of federal antitrust law doesn't mean that we have to follow something that one federal district judge in Alabama does. I mean, you could just as well get harmonization from Judge Huppert correctly deciding how federal antitrust law works, right?
Well, this is such a unique thing, this provider market issue, that and this is the first time it's going to be litigated, and they will have some of the best experts in the country, very expensive to come on each side, right, come and talk about this. And the point is that we need to get it right, because if Iowa says, well, no, we think it's not okay, and they blow up the whole blue card system in the federal court and the federal system, going all the way up to the Supreme Court or the Second Circuit or wherever it might be, says it's okay, then what do? We go back? We go forward? I mean, this is healthcare, and so I understand that it's going to take a long time. But when there's something this complicated, perhaps it should take a long time. And in addition, they have to show here, they'll have to show anti-competitive effects. And so what does that mean? And we show pro-competitive benefits. That means we're going to have to bring in all the other blues, not bring them into lawsuit, but we will show how necessarily this is a nationwide benefit, the blue card program. This is not just an Iowa thing, and the court will not be able to just look at what's happening in Iowa because the product, the blue card product, has a national scope. That's already happening in the MDL. There's no reason to relitigate that already in this case. And then they have to prove anti-competitive effect. So, okay, so their prices are pushed down because of the blue card program. That's their theory, right? Well, they will have to show that. And where? Well, does that mean that insurers will come into the entire state, part of the state? Most likely just cities, because that's where the higher margins are, not the rural areas. Well, will they actually create chiropractor provider networks that are as big as Wellmark's? Not every, if United Healthcare comes in or some other healthcare company, they're already here, but some other blue, comes into the Wellmark territory, this is the hypothetical we have to work under, then are they going to create a network of chiropractors that's as big as this one? Or might they have a very small chiropractic network? So all of these people in this class, only maybe 20% of them will be affected. These are all the things that are actually being litigated. And to your point, I think, Justice Hecht, it's not just the end of the MDL. Under federal law, under Dukes, under hydrogen peroxide, which is a Third Circuit case, which is kind of the antitrust version of Dukes, the court will have to decide many substantive areas of antitrust law, all these cutting-edge issues. It will have to reach them in the class certification briefing or order. That briefing is going to start at the end of this year, most likely. It hasn't been officially set yet, but will likely start. At that point, we will know a lot more about what the world looks like and about this complex blue card program and its effect on antitrust law. So yes, it's a kind of an open-ended to the end of the MDL. What does that mean? Well, I would submit it's within the district court's discretion to decide what that means, and also to revisit the situation if there is something that changes it. If a class certification ruling comes out and there are all kinds of important things that really give us the lay of the land, and we can say, okay, let's start litigating this Iowa case. It seems to me that it is within Judge Huppert's discretion to revisit his issue. He has complete jurisdiction over the case.
So the bellwether cases will be tried after the conclusion of the MDL pretrial, or might?
No, they might be tried before, well, I guess they're supposed to be tried coming in a year. Discovery is now likely going to be extended, so that will likely be extended to the end of 2018. So that might happen around the same time, the class action order and the bellwether trials.
Is there discovery going on in the MDL right now? Depositions being taken?
Yeah, and the effect of the blue card program on prices, they have had mountains of discovery, claim data. They're reviewing tons of these things. So, the elements, what people have to prove to show up to win on this kind of theory takes an incredible amount of data and an incredible amount of analysis. So there could also be an issue of what happens if this case jumps ahead of the MDL in terms of what rights do then the chiropractors in Iowa have to know. There's an MDL going on here, but now you're being asked to join this Iowa case, which really is just as broad in terms of the general theory, but maybe there's not as much expert analysis. Do they have to be told that there's this MDL? Or which one do they opt out of? At what time? How do they know to opt out of which one? There are a lot of problems if these two cases move in parallel with each other.
Mr. Koopmans, would you respond to Mr. Wandro's argument that that there's not complete overlap here, and that there is, to a certain extent, part of the claim asserted here in Iowa that is not going to be addressed in the MDL?
Well, that would be the discrimination claim, I guess, and there, like as I said before, there is no such thing as a discrimination claim under 553(4) of the Iowa Competition Act. So that claim isn't that, or in the Sherman Act, which is the federal counterpart. That claim doesn't exist, so that's why it's not in the MDL. If they want to try to litigate such an issue, discrimination claim, which federal courts have said don't exist, then we can do that, I suppose. But the idea, the main claims, this geographic market division claim that the Blues do not go in each other's territory, and therefore they're not competing for the provider's services, or that the Blues are sharing provider networks, and therefore that they are charging the same prices, because by definition the use of the is the use of the same prices. Those two claims overlap. And they've also argued that, well, because Wellmark's HMO, which we call WIPI, Wellmark Health Plan of Iowa, is not in the MDL, that there's not some overlapping parties. But again, this is broader than just parties, because it's really about the issues and the effect of the Blue Card program, generally speaking. But that's also kind of an incorrect statement. In the MDL, Wellmark Inc. was sued and its subsidiaries. I think it's paragraph 174 of the complaint. But the allegation that defines who Wellmark is, the plaintiffs are making clear that they are suing Wellmark and all of its subsidiaries, and it lists 1.8 million insureds in that paragraph. That includes all the insureds under WIPI. So WIPI really is part of this MDL.
About this theory, I'm just looking at their petition. And we've heard about this theory before in the other case, the notion that Wellmark allegedly conspires with other healthcare providers, non-chiropractors, to have chiropractors pay lower reimbursements that clearly is not a theory that's asserted in Alabama. I mean, the other providers are plaintiffs, right?
I'm not sure I understand the theory. I mean, it's maybe an allegation that's in there because Wellmark once upon a time was created from doctors, and they have never said that that's our theory here or that we're moving under, even though we described their claims. Judge Hubbard was told what's in this case. They had the opportunity to say why this case is different. They never said anything like that. And these cases have proceeding, as you've seen over and over again, where there's this master complaint that just throws everything in, all these different allegations about discrimination that were originally related to all the panoply of claims that were alleged in the first Mueller petition, right? And so every time what we've done in Abbess, what we did, and then in Mueller, what we did later on, is we've looked at it and said, okay, what are you really doing? And we've cut it down as to what their claims really are in this case. So that's what we did in our opening entree to file the motion to stay. Said, look, they have now made these claims. Here's what those claims mean. Those same claims are in the MDL, and they said nothing about that. And so for this court to then tell the district court that it abused its discretion by not considering this hypothetical claim that we're not really sure is in there or not, I think would be a step too far. I see that my time is up.
One other thought, would it make sense to include language in our opinion hypothetically if we said it's okay to stay for now, but we don't like the indefinite part, and that and leave it open for either side to revisit the stay in district court in a year or two or so?
Absolutely, and I think it's within the district court's inherent authority to do exactly that anyway, and so we would have no problem with something like that. Thank you.
Thank you as well, Counsel. Mr. Wandro, you may present your rebuttal.
Just a few points. I'm not so sure about the discrimination as not being recognized by the Sherman Act or the Iowa Anti-Competition Act. I think the focus is always on the conspiracy, people getting together and making decisions that thwart competition. So I'm not willing to concede that at all. Judge, you know, I can tell you that I have been involved, and I know this may not be an appropriate argument, but in very complex antitrust cases that have been handled by judges from the 2nd Judicial District in quiet cases where we've heard all of these arguments. And we've had the judge in that case that involved a class action that was just as complicated as this, a nationwide case, and it was handled very well by the chief judge for 2B at the time. And so, you know, the notion that there's something that is so gigantic and so complicated about a case like this that it requires our courts to defer to federal courts where we don't even get a chance to go down on behalf of our clients to make arguments, I think is disingenuous and in this case, an abuse of discretion. My clients are not part of anything going on in the Northern District. There's been no certification that would bind my folks. And so, and even if we were to do, as you suggested, Justice Waterman, to take kind of let's take a slow approach and see what happens and maybe revisit the issue. I think the one thing to keep in mind, too, is that we're not even talking about the appeals process that could go on. And so I do find consolation in First Midwest, and I keep coming back to the same language, same parties, prompt and complete justice. That's what this court has told us to do in these kinds of cases, where you look to similar cases and you decide whether to enjoin the Iowa action or not. And so we ask the court to keep First Midwest in mind, and I believe that our district courts and our appellate courts have more than enough wherewithal to handle these complex issues. And for that reason, we ask that Judge Hubbard's decision to enjoin this litigation be overturned.
Counsel, before you sit down, I asked you earlier to put on your prognosticator's hat and estimate the length of the MDL proceeding. if this case weren't stayed, how long is it going to take to get your client's relief in the state court?
My hope is that we could get it done within the 24 months that is prescribed by complex litigation in the business court. And I can tell you that our quantum of damages, we're not talking about going down in levels of consumers where you have to have these very complicated econometric models that cost millions of dollars to do. Our case is simple. We're simply looking at the differential between, for the most part, the difference between what was paid to chiropractors and to other healthcare professionals for the same services. So it isn't, and that information is all available. We can get on our computer. We've got it on our Excel sheets. So we don't think we're going to be mired in years and years of more litigation. We would like to get the litigation started, and you know, a lot of it has been done in the Abbas case, where we did have a 4-day trial in front of the ALJ. So it's not like our first go around. I think we can get it done expeditiously. Thank you.
Mr. Wandro, thank you as well.
Thank you, Justice Katie.
Mr. Koopmans, thank you as well. And let me just add, I know these cases have consumed a lot of your time over the last 2 days, but the issues are important, as you know, and quite complex, and your arguments in your briefs have been very helpful, and it's appreciated. Bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.